Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for a decade. You can find me on all social at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, November 20th, 2024. In this week's episode, the husband of a missing woman is now charged with her murder while the search for the mother's body continues. Plus, trial continues for a Marine vet at the center of a fatal subway chokehold incident. But first, breaking news as the man accused of brutally murdering a nursing student during an attempted sexual assault is found guilty by a judge. Today, we are joined by Chris Lomax, an attorney specializing in complex civil litigation. Chris is also an adjunct professor at the University of Miami's Law School and the teaching faculty at Harvard's Trial Advocacy Workshop. Chris, welcome.
Thank you, Josh. Great to be here.
Absolutely. Chris, I always enjoy hearing your commentary and thoughts on these cases, especially knowing that you have a background as a trial attorney. So let's jump right in. First of all, we have a little bit of breaking news as earlier today, as we're recording this, the man accused of the brutal murder of a nursing student near a university campus has been convicted on all counts in an emotional verdict for the friends and family of the victim. Laken Riley was last seen jogging near the University of Georgia when she was attacked, strangled, and struck multiple times in the head and face. Investigators arrested Jose Ibarra for the murder, concluding that Ibarra administered the fatal beating as Riley fought the man who was trying to sexually assault her. While the details of the case are horrific, the case gained additional attention due to Ibarra's status as an undocumented immigrant, leading to public criticisms of the U.S. border control policies. Politics aside, the case has been emotionally resonant for the courtroom observers, with the details of Riley's final chilling moments eliciting sobs from the victim's mother and supporters. Ibarra declined his right to a jury trial, opting to have a judge determine his fate. And following convictions on all counts, he was promptly sentenced to life without parole. Chris, my first question on this is, I've been asked this a lot. Why do you think Ibarra's defense opted for a bench trial in this case?
So normally, as a defendant, I think you want to take your shot with a jury because you just need one person to see it your way to hang the jury, or several people to convince everyone that maybe you should be found not guilty. But in certain instances, when there are graphic pieces of evidence, photographs, videos, bloody, gory things that a jury may be inflamed by, you may have a better shot at arguing certain legal technicalities before a judge. And so I'm thinking that because this was a really, really, really tragic circumstance that happened to a young person, where people would be very saddened by the fact that an innocent person like her was just out having a morning jog and she gets killed, you may have a better shot going before a very sort of pragmatic, legalistic judge who's thinking about the elements of the case as opposed to the sheer tragedy that occurred and wanting somebody to be punished for it.
I think you're absolutely right. That's what I've kind of come to the belief that the strategy behind it was myself, is that usually when you're asking a judge, it's because you're making a very technical, perhaps legal argument, and there's this backdrop of incredible emotion and tragedy that you don't want to cloud the influence that it might cloud jurors, so you're looking for a judge. But in this case, we didn't see kind of those legal arguments. We saw what I would expect to be kind of a straightforward, reasonable doubt, perhaps another suspect. Do you think that was the right strategy to take with this judge, or was that just kind of all that they were left with?
You know, it would be interesting to ask them what they were thinking at the beginning of the case when they started developing their theory versus what they had to work with by the time it was all said and done. I mean, as you know, so many things can happen that would force you to change your strategy in terms of what's going to be admitted, what arguments are resolved in advance of the trial through motion practice, such that what you thought was going to be your theory and your argument is no longer viable. It is odd to me that they decided to go for a bench trial. I'm always inclined to take a shot in front of a jury because it's just they're more than one. It's more than one person, and so at the very least, I get a chance, if you're on the defense, to convince a number of people as opposed to just one person who gets to decide the whole thing.
Yeah, I agree with you. And putting aside, I mean, this was obviously a very strong case. I mean, when you go through the idea that there was DNA under her fingernails, his DNA, there was her DNA found on an article of clothing that he has seen discarding later on. They have GPS tracking and cell phones and video. I mean, it was a phenomenally strong case.
Right.
But what we would refer to a case like this, when you're taking a bench trial, is a long plea when I was in the DA's office, because it's all marching towards the same conclusion. And usually in those situations, it's where you have a client, the defense does, that they can't get to cooperate. They can't get to either accept some sort of plea. And again, I know I'm making a long-winded question here, but bear with me. Yeah. In this situation, it's not like I can imagine them offering him much less. So maybe they just thought, you know what? If we're going to do a trial, let's not drag it out. Do you think that could have been part of it?
I mean, that could be it, right? Because jury selection in a case like this would probably take a long time. It's a media case, so you got to eliminate everybody who's been improperly influenced by what they've seen on television. And as a lawyer, it's your job to do that and do it well. I mean, I want to believe that they made the decision that they thought was in the best interest of their client, but sometimes people make decisions for other reasons. So it's hard to say, but it is a bit puzzling to me that they would do this, other than for the sheer possibility that there was some very technical legal issue that they thought they'd be able to argue in front of the judge. Otherwise, I just don't see why it would make sense to make this a bench trial.
Yeah. And they put on an admirable defense. It wasn't like they just kind of folded their hands and sat there through the whole thing. So I don't want to draw those kind of conclusions, but it was a very, very strong case. I watched some of the prosecution closing arguments, and I was chatting with my wife about it, and she said, well, she's doing such a great job. And I said, well, sure. When you've got all those facts in your favor, it's hard to not knock it out of the park in closing arguments like that. I don't know. Very confusing to me. Yeah.
They had everything. I mean, they had, in the world of victims, you couldn't really get more innocent than a college student trying to get an education, going out and exercising, right?
Yeah.
There are other situations where you have people who get in a road rage accident and one person cuts off another and they flip the bird, and, there's a back and forth and someone takes it too far, but you could find somebody on the jury say, well, I can relate to what it feels like for somebody to cut me off and throw a bird at me in front of my kids and use all kind of language. That would tick me off too. But there is nothing that's, other than being redeemable about this young lady. She was not doing anything to anyone, trying to live her life. And so it's just a really, really hard case for the defense. And, they did what they had to do.
No, you make an excellent point. It is truly a nightmare. And I know that we use that term probably more often than we should, but this is a situation where, like you said, completely innocent victim doing the most innocent of things, out for a jog, middle of the day, nothing that anybody would say, well, that's high risk behavior. She gets assaulted like this, and the text messages from her mother while she's trying to find her are just heartbreaking. So yeah, not any kind of case that you think a defense attorney would really have much to dig into. What is next for Ibarra? Could he face deportation? Will he serve his sentence here? How will that work out?
Well, if he's sentenced to life without the possibility of parole, the state of, I guess, Georgia is going to want to get its penance from this. You owe us this time, and so he's going to have to serve that time. The only way I could conceive of him leaving the country before that is if there's some deal that is struck between governments to say, we'll give you these inmates in exchange for these inmates. But I don't think he's someone who's on the list for something like that. So in ordinary circumstances, he would be here until he served his sentence that he owes to the state of Georgia. And at that point, if he were to complete it somehow, I don't know if it was to be reduced for some reason, and they changed the law or they changed his sentence, then he would likely be deported back to his country of origin.
Yeah. Yeah, one of those cases that kind of got swept up in the political zeitgeist for issues not really involving the crime itself. But it is good that I think we took a moment today to focus on, the victim and the victim's family, and hopefully they're finding the smallest bit of closure now that he has been convicted and sentenced to life without parole.
If you're ever worried about the safety of your home and family, there is no better time to act. Right now, you can get 60% off a new Simply Safe security system. Their best deal of the year, Simply Safe, is the home security I trust. I've been using it for years and love the peace of mind that it brings knowing my home is protected 24/7. Now, our True Crime News listeners can get 60% off today by just visiting simplysafe.com/truecrime. It doesn't matter where I am. Simply Safe helps me feel safe. One of the things I really like is how easy it is to set up and use the system. Plus, Simply Safe helps stop intruders before they break into your home. Unlike old school systems that only take action once someone is already inside your home, Simply Safe's Active Guard outdoor protection changes the game by preventing crime before it even happens. If someone is lurking around or acting suspiciously, those agents see them in real time, talk to them directly, set off your spotlights, even call police before they've had a chance to break in. Plus, there are no long-term contracts, no cancellation fees, and it's about $1 a day for all of this protection. Simply Safe is offering True Crime News listeners exclusive early access to their Black Friday sale. This week only, you can get 60% off any new system with a select professional monitoring plan. This is their best offer of the year. Head to simplysafe.com/truecrime. That's simplysafe.com/truecrime. There's no safe like Simply Safe.
So let's move along to New York, where another case that's become a political lightning rod is underway as a former Marine veteran faces trial for the fatal choking of a man on the subway. Daniel Penny is charged with the death of Jordan Neely, a street performer who was homeless at the time of the incident. Penny's defense maintains that Neely was experiencing a mental episode when he began acting erratically, threatening other passengers, leading Penny to restrain the man. Prosecutors allege Penny's restraint went way too far, applying pressure to Neely's neck for nearly 6 minutes, much of which was recorded on video by a fellow passenger. Testimony thus far has included accounts from witnesses who were riding that day, along with expert assessments from a martial arts instructor and the medical examiner who performed Neely's autopsy. Prosecutors rested their case after the examiner's testimony, with the doctor ruling conclusively that Neely died from compression to the neck and likely would have survived if the pressure had been released 2 to 3 minutes earlier. Penny's defense will now mount their contrasting view of the incident, attempting to illustrate that the vet acted with bravery in protection of other passengers. While both sides agree that Penny didn't intend to kill the man, jurors will decide the repercussions of Penny's actions, and we will keep you updated as the case progresses. Chris, I just kind of want to just get your thoughts on this thing, because it seems like the prosecution is resting a lot of their case. They've even said as much, that it's not that he acted, it's not that he restrained Neely, it's that he did it for too long. And now, according to their medical examiner, that's as little as 2 to 3 minutes. Do you think that's enough to convince jurors for a conviction in this case?
I think it will be extraordinarily difficult. This is a hard case for both sides. This is, I may try to take this and use this in one of my law school exams, because it's one of those quintessential law school exam type questions. On the one hand, you have an individual who's not a law enforcement officer, right? Who's not trained to take down suspects and to restrain them and use an appropriate level of force necessarily, right? He was a military person, but let's just assume that he's just an everyday guy, which is what the law will view him as. One, he does not necessarily have the right to use force against another person unless there is some defense of self or defense of others that would justify that use of force. So as a fundamental premise, I think you need to, for his purposes, the defendant's purposes, establish that there was a true threat that would have necessitated the use of force. And then the next, when we call it self-defense in this context, question I would ask is whether the force that he used was reasonable. In the context of self-defense, if someone has sort of like flicked you in the ear, you don't get to shoot him, right? The defense has to be proportional to the potential harm. I understand that Mr. Neely, who had suffered from some sort of mental health issue, apparently, according to what is being argued, was threatening to kill people and making all types of outbursts. But some of the witnesses stated that he had not actually approached anyone or actually harmed anyone at that point. So what we have to grapple over is whether his potential, the potential harm that he may have caused was so imminent that Mr. Perry would be justified in using the level of force that he did. And then for the amount of time that he did, right? Now, on the other hand, if he was allowed to use force, the question becomes, did he have the requisite mental state to say, well, he knew that what he was doing was a bridge too far. And I think it's really hard, first of all, to prove what's going on in someone's mind. He is someone who is trained to be engaged in difficult sets of situations like this. And however his training may have kicked in will be a factor as well, I'm sure. But I think it's really, really close. I'm saddened by the fact that he actually killed this person, but I also understand that it seems as though he was trying to prevent others from being harmed. And I think the prosecution has acknowledged that as well.
You did such an excellent job of explaining that you actually gave me flashbacks of law school, because that's exactly how we would play it out. You end up with kind of more questions than you have answers because you're really just trying to explore these scenarios. I think you're absolutely right. It is an excellent case. Putting aside the tragedy of all of it, is excellent case, facts, scenario to discuss when trying to understand reasonableness and self-defense and everything else. I'm gonna kind of add to your questions here, because the prosecution seems to have admitted that the actual starting to use force is not a problem. So if we're going back through analyzing it the way you just outlined, his perception of a threat, they find to be reasonable. His even initial response to that threat, they find to be reasonable. But at some point, they felt that went from reasonable to unreasonable in the length that he was restraining this person. And to me, that really bothers me, because part of what we're trying to do in the criminal law is create some precedent, some guidelines for people to understand what's acceptable behavior and what isn't. So you got this crowd of people on the train who were saying, we were afraid. We were glad he stepped in. There's videos of other people even trying to assist him in restraining Neely. But now the prosecution is saying all of that was great until about 2 to 3 minutes you went too long. Is that it? Just, do you see where I'm going? Where it's like, that's where it really begins to bother me.
So here's where I think the government's case is most powerful. There are other witnesses who I believe at a certain point said to Mr. Petty, I think that's enough. I think you need to stop, right? You need to loosen up. Because if we're trying to establish what a reasonable person would do under the circumstances, well, we don't have to imagine, because there were other reasonable people around who said, all right, I think we need to let him breathe. Said, I think you're hurting him. If they can bring in enough people to say, well, I thought at that point, he had enough, then maybe that's going to be persuasive if it's admitted. But it's extraordinarily difficult. A 2 to 3 minute difference in a circumstance like that is like a second, right? And he's thinking the entire time, Mr. Petty, well, if I let him go, is he going to get back up? And if he does get back up, what is he going to do? And from his perspective, I'm sure he would say, I'm going to be target number one because I'm the person who's been engaged with him. So his self-defense argument, I think, is pretty strong here. But I also think that the government has a pretty decent case in arguing. Maybe I think I may go a step further than the government to say, well, using the chokehold in that way was probably a bit too far. Could you have, hugged him around his torso? I mean, if you've done any sort of, and maybe that's why they call the martial arts person, but if you've done any studies and you've paid attention at all to what's going on in law enforcement, chokehold is not cool. Like, that's not even something that is permitted by many law enforcement organizations in the country anymore for this very reason. You kill people. We've seen it happen on video where people have died because of chokeholds. So will the court extend that same reasoning to a lay person, if you will, who has not been trained on the danger of using chokeholds? We'll see.
No. For a moment, if you can place yourself in the position of Penny's defense team, would you advise him to take the stand? Because of so much what you've just talked about seems to have to really do with what was taking place between his ears and how he perceived that threat and how, what was going through his mind as he's continuing to restrain this person. Do you think this is one of those rare instances where you might have advised your client to testify?
Potentially. I think it depends on how well I can prepare him to testify and how well he can follow my instructions and my guidance on how he needs to conduct himself on the stand. The last thing we want is someone who gets on the stand and comes across as arrogant or callous or unwilling to cooperate in a cross-examination because he's just obstinate. That's not the type of person who we want to put on the stand. But if he's measured and controlled and can articulate why he did what he did in a way that is persuasive and convincing, and even in a way that would cause people to feel compassion towards him, then I think this is a great case to put the client on the stand.
Yeah. As always, Chris, that's why we like having you. Excellent analysis. We will see what his defense team actually decides to do as we continue to follow that case. Let's finally move on to San Antonio, Texas, where the husband of a mother of 4 has been charged with her murder as authorities and volunteers continue to search for the woman's remains. Suzanne Simpson was last seen outside her home by a neighbor more than a month ago, and concerns about her well-being quickly made their way to authorities. A witness claimed that the day of the disappearance, the mother had been seen in a physical altercation with her husband, Brad Simpson, before the witness heard screaming in the woods near the residence. While Mr. Simpson was charged with family violence days after her disappearance, it wasn't announced until weeks later that he had been charged with her murder. Family members have said the charge is the start of the healing process, with Brad's own brother pleading with Simpson to cooperate with authorities to find Suzanne's body. We will continue to update you on the search for justice and for the slain mother in this case. Chris, according to a recently released affidavit, Simpson's vehicle is seen at various locations with trash bags and what they describe as a blue tarp wrapped around an unknown object that could appear to be a body in the bed of his truck, while he's making purchases at Home Depot for cement and cleaning supplies. And then they also now have this stranger that he approached in the parking lot asking for directions to the nearest dump. I think I know what your answer is going to be, but what do you make of all of this new evidence we're hearing about?
Sounds all bad for Mr. Simpson. Unless he's engaged in some industry that could explain away why he would do any of that, then that just sounds really, really bad. I don't think you or I could explain away engaging in that kind of conduct, asking those types of questions. But we all know we live in a world that is full of surveillance. There's not many places you can go and you're not caught on camera. There are not a lot of things that you can purchase that won't be tracked. So it sounds like he has thrown caution to the wind and decided to just go about this in a very, I would say, open and notorious way.
Yeah.
But I guess we'll find out exactly what it was he had. But it sounds like, unfortunately, maybe Miss Simpson. So that's terrible.
Yeah, it is. The affidavit is remarkable because talk about using modern day technology. They've got surveillance. They've got vehicle plate readers. This is something that some of our listeners and viewers may not know about, but even if you're not on video, there are license plate readers that are automatically recording vehicles as they go by, recording those plate numbers all over the place. So even if it's not taking a picture of that vehicle, it's saying a vehicle with this license number was seen at this location at this time. So that, in conjunction with phone tracking and everything else, they really have created a remarkable tapestry in this case. Yet they still cannot find her body. So I'm curious, and I've been asked this before, do you think there's any way that authorities might strike a deal with him in order to locate her body? Something less than, never seeing the outside of a prison again in exchange for telling the family members where her body is so that they can finally have some peace.
So I think the first step in that process would be to consult with the family members to find out if they would be okay with that as an outcome. Because, it has been some time, but it has not been so much time that has passed that it makes it all but impossible to locate her body. I think a lot more work can be done using all of the information that they have. But it is clear to me, based upon some of the statements that have been made by the family members and the pleas that have been made during press conferences, that they just want closure. And, as we've talked about in other cases, sometimes family members are okay with the idea of another family member going to jail for a long time, but not forever, because that person is still a member of the family. And in a situation like this, where you have a husband and wife and there are children and there are sisters and brothers and, their parents, it's a double tragedy for her to be deceased and for him to go to jail for a very long time. You're talking about kids losing both of their parents. And so if there's an opportunity for redemption on his side, for rehabilitation, where he may be able to say, hey, I did this, very sorry about it. I'm happy to do my time, but maybe I don't have to go away forever. That seems like an outcome that everybody could possibly live with.
Yeah. Yeah. And to drive home your point, one of the unnamed witnesses in the affidavit is the 5-year-old daughter of this couple. And she apparently was able to explain to authorities witnessing an argument between her parents the evening before she went missing. Just that, when I got to that part, just absolutely crushed me to think that little girl is young and innocent enough, maybe not to appreciate entirely what's going on, but enough to appreciate that was important, what she witnessed, and now she might never see mommy again. My God.
Kids are really smart. I have 2 kids, 6 and 8, and sometimes the things that they perceive that you think they would miss, they're absolutely tracking it the entire time. They come to you and they say, hey, Dad, are you upset? Or are you mad? Are you okay? And you think you're hiding it. And you think that they don't hear the discussions and some of the more serious conversations that are happening, but everyone should be mindful of that. They are intelligent beings. And so this is an unfortunate example of all of the smaller things that we all deal with on an everyday basis. But this is just a tragedy, however it shakes out.
That's so true. They may seem like they're ignoring you, but they've got that little tape recorder brain of theirs on at all times. Chris, this has been a really enjoyable conversation. Thank you so much for coming on this week. Where can people find out more about you?
Sure. Well, thank you for having me. It's been great. I've enjoyed it. So I'm on all of the places. I guess it's still called X. I heard they created a new one, but I still have my account. It's same for Instagram and for X or Twitter. It's Lomax, CEELOMAX. And then our firm has the same, we use the same apps, Lomax Legal, LOMAXLEGAL. You can also check out our website, www.lomaxlegal.com. So it's been a great pleasure. If I don't talk to you before, have a happy Thanksgiving for all who celebrate, and especially you, Josh.
You too. Appreciate that. And I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, please check out my brand new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments you would like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.